So we need to talk about something that should set off alarms for anyone who cares about constitutional rights. The Supreme Court has issued a 9-0 unanimous decision on excessive force and the 4th Amendment. The court sent the case back down with clear instructions to the lower court, but now the plaintiffs have already had to file for new Supreme Court review based on the fact that the 5th Circuit essentially decided to ignore that unanimous ruling by the Supreme Court and they just tried to apply a different doctrine. So let's talk about what's going on in this critical case that's now already back in front of the Supreme Court. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is simply to subscribe. You can also click the like button. That just tells the algorithm that you appreciate this content, and so it shares it to more people. I also want to thank one of the main supporters of this channel, which is First Form. You guys know that First Form's an amazing company, pro-freedom, pro-America. They support the 2nd Amendment, but also they have amazing supplements. And if right now you're still on your New Year's resolution and you're trying to get healthier, right now I've been trying to do the same thing. I've lost about 18 plus pounds since the beginning of this year. And a lot of the supplements that I use and a lot of the apparel that I use when I work out is coming from First Form. So if you're interested, you can check them out using the link down below. And if you use that link and you order any supplements, you can get a free 5-pack of protein sticks. Now, as I mentioned in the intro, in this video, we're going to be discussing a case already back in front of the Supreme Court, despite the fact that the court already just recently issued a 9-0 unanimous ruling in that very case. And again, that just came months ago. This case is called Barnes versus Felix, and it centers around the 4th Amendment and when police can use deadly force. In this case, a police officer pulled over Ashton Barnes for what began as a minor toll violation involving a rental car, and there were some issues where he was caught on camera and the vehicle had some toll violations, so he was pulled over. The officer ordered Barnes to exit the vehicle. Barnes opened the door, acted as if he was going to comply, but then he attempted to drive away. So the officer, reacting in a split second, decided to jump onto the ledge of the vehicle on the open door, the ledge of the vehicle. He decided to jump on that as it was moving and driving away. And as it was driving away, in about 5 seconds was the total time, the officer decided to fire 2 shots at Ashton Barnes. Both struck him, and then he was fatally wounded. Now, because of this incident, Barnes' mother sued under Section 1983, alleging excessive force in violation of the 4th Amendment. Now, on review, the lower court originally ruled in favor of the police officer using something called the moment of threat rule. Now, under that rule, courts look only at whether the officer was in danger at the exact moment deadly force was used. Everything that happened before that moment is actually ignored. So using that very narrow framework, the district court and the 5th Circuit ruled in favor of the officer. That then led this case to go to the Supreme Court last term, and on review for the first time, the Supreme Court issued a 9-0 unanimous decision in favor of Ashton Barnes and his mother, who sued the police officer, and they rejected the whole moment of threat analysis. The court held that excessive force claims must be analyzed under the totality of the circumstances, not just the final split second that the interaction occurred. They said that you cannot just use the officer's immediate perception of danger, but you have to look at everything leading up to the encounter. This rule goes back to long-standing Supreme Court precedent, which requires courts to examine a full factual context surrounding the use of force in that type of incident. So the Supreme Court sent the case back down to the 5th Circuit with very clear instructions. Reevaluate this case and this incident using the totality of the circumstances standard. But here's where things got very unusual in this case. After the case went back down to the 5th Circuit, very quickly, the 5th Circuit decided to just simply reevaluate on their own and issue a new ruling on their own. They did not hold oral arguments. They did not request full merits briefs based on what the Supreme Court said, and they did not send the case back down to the trial court for a new evaluation. Instead, the panel issued a new ruling again on their own, and once again, they ruled in favor of the officer. But this time, the 5th Circuit used a different justification. The court reasoned that because Barnes tried to flee in his vehicle, he posed a risk of flight that could endanger others on the roadway. Therefore, the officer's use of deadly force was reasonable according to the 5th Circuit. And in this new petition filed to the Supreme Court, they argued that effectively this new ruling by the 5th Circuit creates a per se rule allowing deadly force anytime a suspect in a vehicle poses a risk of fleeing from police officers. And that is the core issue that is now being presented to the Supreme Court. Is this, risk of fleeing actually justify this type of deadly force? So just months after the Supreme Court issued that 9-0 unanimous ruling in this case, it is back in front of them for a clarification and also potential expansion. The new cert petition argues that this risk of flight doctrine directly conflicts with existing Supreme Court precedent. In particular, under Tennessee versus Gardner, officers cannot use deadly force simply because a suspect is fleeing. Deadly force is only justified if the officer has probable cause to believe the suspect poses a significant threat of death or serious physical harm to others. But according to the petition, the Fifth Circuit's rule that they created effectively says something very different. It says that the mere risk of escape in a vehicle can therefore justify deadly force. And the petition argues that that transforms, SCOTUS precedent into something that the Supreme Court never actually approved. The petition also argues that the Fifth Circuit's new rule puts it in direct conflict with other federal courts of appeals who have also looked at this type of issue. Multiple circuit courts have held that shooting a fleeing driver is unconstitutional unless the driver poses an immediate and serious danger to others. But the Fifth Circuit's ruling in this case actually suggests that risk of flight alone may be enough to use deadly force. So just the fact that you may flee may be a justification under the Fifth Circuit. That creates a major split in how federal courts apply the Fourth Amendment across the country. And when circuit court splits and these type of things appear and kind of arise, especially involving constitutional rights, that's exactly the kind of situation where the Supreme Court often decides to step in. So where does this currently leave us with this critical case? Well, you had the prior 9-0 Supreme Court ruling in this case. They've already looked at this, issued a 9-0 ruling in favor of the family. They ruled against the officer and the moment of threat rule. The case was then sent back down to the Fifth Circuit. The Fifth Circuit looked at this case on their own, did not hold oral arguments, did not request additional briefs, and they ruled the same way, just using a different doctrine. And that created a potential circuit split across the country on a serious Fourth Amendment issue. And now a new petition is filed to the Supreme Court asking them to once again intervene in this case. At this point, this issue isn't just about excessive force, it's whether lower courts are actually applying Supreme Court precedent or simply trying to relabel the same reasoning that the court already rejected when they reviewed the case on the first attempt. So the Supreme Court will now decide whether to grant cert again in this Barnes versus Felix case. If they do, the court will likely address a major constitutional question. Can police use deadly force simply because a suspect might flee in a vehicle? Or does the Fourth Amendment require a real and immediate threat to justify deadly force? Given that the court already ruled unanimously once in this case now is a serious candidate for another round of Supreme Court review, and maybe once again they will reject what the Fifth Circuit said in a new 9-0 decision. So that's what's currently going on in this critical case. That's what the latest developments are in the Barnes versus Felix case. There was that unanimous Supreme Court ruling, the controversial lower court decision, and now a new petition for Supreme Court review has been filed based on what the Fifth Circuit just said in this case. So that's where this currently stands. It's now going to move forward again at the Supreme Court level. As we get more information, as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this type of two-way content, and so it shares it to more people. But as always, thank you so much for all of your support, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.